Good afternoon, Canada. Alex Monahan here again. Foundations Party ineligible. Today's date is April 12th, 2017. And it's just going to be today's video. We're going to keep moving through the Immigration Protections Act, get through it, so that we can see what's been going on with people coming in and understand what they should be doing and what our response as a country should be. And again, I just thought I should let everybody know that I'm kind of dyslexic, or I have some reading and writing disorders. So I know it's going to be a little choppy, so please bear with me. So without any further ado, we're going to pick up where we left off under exceptions to paragraph 1.2c. 1.21, paragraph 1.2c does not apply in respects of foreign nations, A, who, in the case of removal, would be subjected to the risk to their life caused by the inability of each of their countries of nationality, or if they do have, if they do not have a country of nationality, their country of former habitual residence, to provide adequate health or medical care, or B, whose removal would have an adverse effect on the best interest of the child directly affected. Non-applications of certain factors. 1.3. In examining the requirements of foreign nationals in Canada, the minister may not consider the factors that are taken into account in the determination of whether a person is a convention refugee under Section 96, or a person is need of protection under Section 97(1), but must consider elements related to the hardships that affect a foreign national. Provincial criteria, subparagraph 2. The minister may not grant permanent residence status if the foreign national referred to in subsection 9(1) is the foreign national that does not meet the provincial selection criteria applicable to that foreign nation. Humanitarian and compassionate consideration ministers on invitation. Paragraph 25.1. Subparagraph 1. The minister may, on the minister's own invitation, examine the circumstances concerning the foreign national who is inadmissible other than under sections 34, 35, or 37, or who does not meet the requirements of this act and may grant the foreign national permanent resident status or an exemption from any application criteria or obligations of this act if the minister is in the opinion that it is justified by humanitarian and compassionate consideration relating to the foreign national, taking into account the best interests of a child directly affected. Examination. Subparagraph 2. The minister may examine the foreign national from the payment of any applicable fees in respects of the expansion of their circumstance under subsection 1. Provincial criteria. Subparagraph 3. The minister may not grant permanent residence status to foreign nations referred to in subsection 9.1 if the foreign national does not meet the province's selection criteria applicable to the foreign national. Public policy considerations, paragraph 25.2, subsection 1. The minister may, in examining the circumstances concerning a foreign national who is inadmissible or who does not meet the requirements of this act, grant the person permanent resident status or an exempt from an applicable criteria or obligations of this act if the foreign national complies with any conditions imposed by the minister and the minister is of the opinion that it is justified by public policy. Consideration. Examination. Subparagraph 2. The minister may exempt a foreign national from a payment of any applicable fees in respects of the examination of their circumstance under section 1. Provincial criteria, subsection 3, the minister may not grant permanent resident status to a foreign national referred to in subsection 9.1 if the foreign national does not meet the province's selection criteria application to the foreign national. Conditions, subparagraph 4. The conditions referred to in subparagraph 1 may include a requirement of foreign national to obtain an undertaking to obtain a determination of their eligibility for the third party that meets any criteria specified by the minister. Regulations. Paragraph 26. The regulations may provide for any matter relating to the application of selection 18 to 25.2 and may include provisions respecting A. Entering, remaining in and re-entering, B. Permanent resident status or temporary resident status, including acquisition of that status, B1, declaration referred to in subsection 22.1, subparagraph 1. C, the circumstance in which all the parts of C, the circumstances in which all the part of the consideration referred to in section 24 may be taken into account. D, conditions that may or must be imposed, varied or cancelled individually or by class on permanent residents and foreign nationals. D1, undertakings that may or must be given in respects to the requirements made under subsection 25.1 or undertakings referred to in subsection 25.2, subparagraph 4, and penalties of failure to comply with undertakings. D.2, to determine of eligibility referred to in subsection 25.2, subsection 4. And E, despite a guarantee of the performance of obligation under this act that are to be given to the minister. Rights and obligations of permanent and temporary residents. Paragraph 27. Subsection 1. A permanent resident of Canada has the right to enter and remain in Canada, subject to the provisions of this Act. Conditions. Subparagraph 2. A permanent resident must comply with any conditions imposed under the regulations or under instructions given under subsection 14.1, subparagraph 1. Resident obligations, paragraph 28, subparagraph 1. A permanent resident must comply with a residency obligation with respects to every 5-year period. Application, subparagraph 2. The following provisions govern the residency obligations under subsection 1. A permanent resident complies with the residency obligations with respects to a 5-year period if on each of a total of at least 730 days in that 5-year period they are I. physically present in Canada, 2. outside Canada, accompanied by a Canadian citizen who is their spouse or common law partner, or, in any case, of a child, their parent, 3, like eyes, outside Canada, employed on a full-time basis by a Canadian business or in the federal public administration or the public service of a province. 4, outside Canada, accompanied by a permanent resident who is their spouse or common law partner, or, in any case, of a child, their partner, and who is employed on the full-time basis by a Canadian business or in the federal public administration of the public service of a province, or 5, referred to in regulations providing over other means of compliance. B. I'm just going to rearrange myself here, if you'll excuse me. It is sufficient for a permanent resident to determine or to demonstrate an examination. 1, if they have been a permanent resident for less than 5 years, that they will be able to meet the residency obligations in respects of 5-year period immediately after they become a permanent resident. 2, if they have been a permanent resident for 5 years or more, that they have met a residency obligation in respects of 5-year period immediately before the examination. And C, a determination by an officer that humanitarian and compassionate compassionate consideration relating to a permanent resident, taken into account the best interest of a child directly affected by the determination, justify the retention of permanent residency status, overcomes any breach of the residency obligations period to the determination. Right of temporary residence. Paragraph 29, subsection 1. A temporary resident is subject to the other provisions of this Act, authorized to enter and remain in Canada on a temporary basis as a visitor or as a holder of a temporary residence permit. Obligations, temporary residence, subparagraph 2. A temporary resident must comply with any conditions imposed under the regulations and with any requirements under this Act, must leave Canada by the end of the period authorized of their stay, and must re-enter Canada only if their authorization provides for re-entry. Work and study in Canada. Paragraph 30, subsection 1. A foreign national must not work or study in Canada unless authorized to do so under this Act. Authorization 1.1. An officer may, on application, authorize a foreign national to work or study in Canada if the foreign national meets the circumstance set out in this regulation. Instructions. Subparagraph 1.2. Despite subsection 1.1, the officer shall refuse to authorize the foreign national to work in Canada if, in the officer's opinion, public policy considerations that are specified in the instructions given by the minister justify such refusal. Concurrence of second officer. Subparagraph 1.3. If applying subsection 1.2, any refusal of to give authorization to work in Canada requires the concurrence of a second officer. Purpose 1.4. The instructions referred to in subsection 1.2 shall precede public policy considerations that aim to protect foreign nationals who are at risk of being subjected to humiliating or degrading treatment, including sexual exploitation. Okay, so I'm going to end this first half here for right now, and once I've got everything uploaded, I will pick up and do the second part.